Okay, so we're going to start in about 2.5 minutes. So I'm just going to set us up. So I'm going to move you to the other scene. So I'm going to remove your video from this temporarily.
Okay.
So I'm going to do that, and then when I start the presentation, I'll play the intro and then cut to you, and then you can begin.
Awesome. Okay. Hello, everyone. My name is Mahmoud Faisal Elkhatib. I am known as the Bowtie Attorney with EB Haas Attorneys at Law. We are a foreclosure defense firm, and we focus majority of our work on real estate, foreclosure defense, real estate transactions, and building code violations. And we are here today to talk about borrower side foreclosures in Illinois. What do the timelines look like? What are the options? What is a litigation strategy, and how to move forward? So feel free to drop questions in. I will see them, and we will begin. So one of the things that we're going to talk about is some baseline Illinois procedure as to how the process works, some of the borrower defenses that are available, as well as what motion practice would look like, and what are some of the things that we can you would do. And then also pathways to loss mitigation. Awesome. All right, moving on to the next slide. So one of the things that by the time we're done with this, here's kind of the things we want to make sure we've identified. Recognize each phase of the foreclosure that you would have in the foreclosure case, and what are the legal implications of each of those pieces. Evaluate the defenses that are available, and assess the borrower side defenses, procedural challenges, and possible offensive tactics to take. I don't mean like being offensive. I mean like actually taking the offense. Then we're going to look at some of the motion strategies, some of the things that you can do to target and extend the borrower's leverage. And there's ups and downs, right? So what are the benefits of extending, and what are the benefits of finding a resolution quickly? And then we're going to compare those resolution options and weight out the loss mitigation options and the pathways available, what those look like, what the likelihood is, as well as I'll briefly talk about which ones have been successful and unsuccessful long-term. So one of the biggest things about foreclosure defense is, unlike a traditional litigation case, time is critical, right? And most litigation cases, time is important, of course, but those cases can drag on and foreclosure can drag on. However, when certain things start happening in a foreclosure case, they becomes almost, as each step and each stage progresses, it gets worse and worse, and the options available for the borrower are fewer and fewer. And so some of the options available to talk about for a possibility for resolution are loan modifications, reinstatements, short sales, or negotiated payoff, if there is one. So, and I'll talk about the likelihood of each. So on the loan modification piece, you're going to see that it really depends on the borrower's equity as well as the borrower's financials. And the interesting part about a loan modification is it is unlike a traditional refinance or a financing arrangement where they're checking out the qualifications of just the borrower, whether the borrower can pay. They're actually looking at the qualifications of anybody in the household that can support. So if there's a husband and a wife and only the wife is on the mortgage, they can consider the husband's income. So it's looking at the overall household income, and each bank is different as to what they require from a income to debt ratio. So they're looking at saying, okay, well, if the housing payment, some of them are as 50%, some of them are 35% of person's total gross income or the household's gross income. So those are some of the things that you want to look at for a loan mod. And they're going to look at, and we'll get more details as we progress, but they're going to get into, for example, they're going to require bank statements and income statements and pay stubs or profit and loss statements if they're self-employed. So these are some of the things that a bank will be asking for. And I will warn you two things. One, don't expect it to be approved because very few are. However, it's important to go through that process because you really need to explore that option because they can approve them. But the other piece to be conscious of is that the loan modification, they will delay, and you'll end up with a lot of issues of the bank, I didn't get this document, or I need that document, or we need this document, and they'll continue to play this game. And the critical piece is not to ignore the foreclosure, right? So while negotiating work on the loan mod, should always be monitoring and litigating on the foreclosure side. So the cool thing is when you do these loan modifications, if you have multiple, what I would call bad faith acts on behalf of the lender, then those can be baselines for counterclaims that you can raise against the bank, whether it's under, and I'll give you a few of them, but unfair deceptive practices are one of them. You can use those. You can use the violations of RESPA, FDCPA claims. So there's a range of claims that become available as you work more and more with the banks. It's almost like they trip over themselves because their process and their systems are so messed up. And some banks are definitely worse than others. Reinstatement, we're going to talk briefly about that. So the reinstatement essentially is when, let's say they're 3 months behind or 4 months behind, they essentially are asking from the bank, what is the total amount that's owed today to bring the loan current? And that brings the loan current, and then the case gets dismissed. A short sale, and we'll talk about those dates as well as we're going through the presentation. On the short sale side, the short sale is where the borrower is negotiating with the lender, and the lender is accepting to take less money in exchange for the property to be sold to an independent, unrelated third party. And that's important for a variety of reasons. And most of that has to do with their guarantees that they've gotten from Fannie, Freddie, the VHA, or the VA, FHA, or the various quasi-government entities that back up these loans, as well as the credit default swaps and the default insurance that they got to protect themselves in the event of default. So, and then the last thing is a negotiated payoff, which is highly unlikely. You may be able to get some of the fees waived, but they can't negotiate a payoff that's less than what they're owed because of the fact that if they do that, they essentially have given the borrower a discount, which then invalidates their own default swaps, as well as the guarantees that they got from the federal government, whether it's FHA, the ones we mentioned earlier, FHA, VA, HUD. I'm blanking right now, but I mentioned them earlier. VA, right? Fannie Mae, Freddie, Fannie, etc. So it's unlikely to get a rate negotiated payoff if it's a resold loan. So if it was sold on an open market. But if it's a bank that has the loan internally, they might accept a negotiated payoff depending on the circumstances. So that said, one of the things we want to talk about is the foreclosure law framework. So in Illinois, it is a judicial state. So by judicial state, that means in order for the bank to foreclose, to take the property. So essentially, borrower defaults, and now the bank is wanting to enforce their note and mortgage action. In Illinois, as a judicial state, they have to file a judicial foreclosure, a foreclosure in a court of law, a complaint, and proceed through the judicial process in order for them to take the property and to foreclose and wipe out all the interest so they can take the property in exchange for what they're owed. There are deficiencies that can come up down the line. We'll talk about that as we progress through, right? And so in order for this to work, they have to file a formal court action. So typically it's 3 months of missed mortgage payments, and then usually they'll step into the foreclosure case. And so by the 4th or 5th month, a foreclosure complaint has been filed with the court. And in any litigation, a complaint is filed, if you're familiar with litigation. And if you're not, when a complaint is filed, the next step is that the parties have to be served. The next big step, right? So you need to notify the parties that the foreclosure has been filed and there's a complaint pending against the defendants. And the defendants in a foreclosure case is anybody that has any interest that is public in the property. And by public, I mean recorded on title. So if there's a second mortgage, if there is a city lien, if there is a water lien, if there is a judgment creditor, if there's a mechanics lien, if there are 2 owners, if there's 1 owner and a lease that is recorded, anybody that has any recording on title will be named in the foreclosure complaint. And including the spouse who may have just waived homestead on the mortgage and may not be on the loan documents, but they still have to wipe out their interest, right? Because they still have an ownership interest potentially in the property. So they'll be named to remove their potential ownership interest in the property. So the next piece is, and this is very critical. And so for those of you who are litigating and just do regular litigation versus foreclosure litigation, this service component is absolutely critical because it is different than every other litigation case in Illinois. And by that I say, in Illinois, if you are served, or let's say you're improperly served on a lawsuit and you're a defendant in a lawsuit, and 2 years go by and you showed up in the court, but you didn't actually step into the case, but you showed up, you said, hey, I'm here, and then you don't do anything. And let's say service was improper. Okay. And as a defendant, you showed up to court, that first case status, and you said, you know what, service is improper, I'm out. I'm not going to deal with this anymore. And then you come back 2 years later and they probably have judgment and they're finished or whatever, and things have taken place in the case. If you never took any other action other than showing up, and this is in a regular litigation case, if you don't take any actions in the case and you don't do anything in the case, and then you show up at the very end and file a motion to quash service, you will untangle the entire case from beginning to all the way back to the beginning, except in mortgage foreclosure cases. And here's the difference. The law changed. There was a law that was passed several years ago that essentially said that if a borrower appears, just simply shows up to the Zoom hearing or walks into court and makes themselves known, that sufficiently is accepting service. And at that point, they have 60 days to file a motion to quash service. And if they fail to do so, service is deemed waived and they have been served. So this is unlike some huge note, right? This is unlike any other litigation case when it comes to service of process. In service of process and foreclosure, if the defendant appears in any way, they have 60 days from the date of appearance to challenge service. Otherwise, it is deemed waived. And if anybody knows anything about litigation and personal jurisdiction is related to this process, you understand how this is such a huge digression away from typical personal jurisdiction laws in Illinois as it relates to appearance and filing and showing up and being served. So now we've gotten service. Then there's a few other steps in between. They got to get judgment. There's going to be a prove up, presuming that if let's say the defendant doesn't do anything, and it's an absentee defendant, right? It's absent defendant. Then they would get a judgment, a default judgment, and from the default judgment, they would move to other aspects of the timeline. We're going to push forward on that and show, right? So you got a default, you got mortgage payments that were missed. You have the complaint for the lender that's filed. So the lender files the foreclosure complaint. Now, coupled with that foreclosure complaint, and you'll hear this a lot, is a lis pendens. So people will presume that when you say lis pendens, oh, there's a lis pendens filed, that means there's a foreclosure. That's not true, right? If you are in litigation, you know that any action against a property, whether it's a quiet title, mechanics lien, or even a building code violation case, a lis pendens will be filed to put the world on notice that an action has been taken against this property, right? So in the case of a foreclosure, they will also have a lis pendens filed, and then the complaint will be filed. Usually those would go hand in hand. And the lis pendens is recorded on title. So that way the world knows, who may not be part of either Cook County or any other of the court clerk systems, they'll have notice on title. So that way a title company pulls it, they'll see there's a lis pendens, which then has to be resolved, right? Borrower is served, and then you get the court proceedings and litigations, and you have the defenses raised and the counterclaims that can come up. So understanding where a client is in the process is critical to know what defenses they have available, what they can do, what offensive tactics you can take to protect and maybe recover damages for the borrower, as well as if there's anything that can be done, because there are points of no return in a foreclosure case. And we'll talk about that coming up. So when does the foreclosure officially begin in Illinois? Right. And so this is a huge misnomer. And if anybody was around in the 2008 crisis, there was a lot of people who thought, oh, I missed payments on my mortgage, I can't afford it, and they would just leave the house. So that's not the case. It's not when you miss the first. So if you want, it's, as you can see the questions, the correct answer in this case is B, when the lender files a foreclosure complaint. So it's not when the sheriff schedules the auction, which we haven't talked about the public auction piece, but we'll talk about that later. And it's not when the bank sends a default letter, because they will send a notice of default. And that will be coupled with something called a notice of acceleration, right? So the person misses 3 payments, they'll send default letters, and then the lender will accelerate the note, right? And says essentially what that means is the entire mortgage, the entire note for the 30 years of that whole note, whatever's left in that 30 years when that payment starts missed, the remaining balance now becomes in full owed that day. That is the accelerating. So they're accelerating the entire amount of the loan to today, and the whole amount is due today. That is what the acceleration takes place. And that is a very key point, right? Because one of the defenses that are out there, and you'll see a lot of, and we're not going to talk about it here, but I'll briefly touch it, is zombie mortgages. And so the zombie essentially is where these are, in Illinois, contract law, a contract is statute of limitations is 10 years from the breach. You can file a claim. That letter of acceleration is a drop dead date saying this is the date of default for the whole thing is owed. And then from that point on, if 10 years and a day pass, the mortgage is unenforceable. So key points. So foreclosure law is a mixture of real estate, finance, banking, civil litigation. So it's a combination of different things that really come together to get where you're at, right? And so let's see, we're going on. So moving on to the next step. So mortgage default. So we talked about here, right? So the typical pattern, we have missed the 3 payments. The borrower has options at this stage, right? So they can reinstate, which we talked about was, oh, you missed 3 payments, talk to the lender, negotiate with the lender, say, okay, I want to make my 3 payments. Now you reinstate, make the full 3 payments that you missed, and now the loan gets back to day 1. We're right back. Default has been cured, right? So this is important. This is like in contract law, if a default in any contract has been cured, then it's cured, right? So there's no more cause of action, no longer are there damages or anything to move forward on that. Same thing in the mortgage foreclosure. If the person reinstates the loan and pays it in full, there's nothing left for the foreclosure to move on. The default has been cured. Because in order for them to move forward in a case, you have to have 3 pieces, right? You need to have damages, you need to have causation, right? And you have to have an injury. And so in this particular case, the causation is the missed payments. So the borrower stopped making payments. That was the cause. The injury is the lender didn't get their payments, okay? And the damage is that they have interest and expenses that came accrued that allows them to collect. So when you reinstate, you're actually zeroing out that process. So the default, the causation that created the injury has been cured. So there's no longer an injury. And so since there's no injury, there's no cause of action. So if they've been reinstated, it is critical that that foreclosure has to be dismissed. And one of the things that we have seen is what lenders will do, and this is, professional note, is professional tips, right? They won't dismiss the foreclosure and they'll keep that running, waiting for the next default. And they'll say, oh, they failed to, they reinstated, and then 6 months later, they defaulted again. Well, that foreclosure is still open. So what they'll do is they'll come in and they'll try to claim that they can continue with the old foreclosure on a new default. And you can't do that. Now, they can amend the complaint and say the previous default has been cured and now we have a new default, and they can amend the complaint to move forward. But that is extremely damaging to the client, to the borrower. From a defensive standpoint, the key is if that's been reinstated, immediate dismissal with prejudice. Now, with prejudice means that they can't pursue on that default, on that injury that they incurred when they filed the first foreclosure, or when they initially filed the foreclosure. And when that default is cured, they can't come back and file against that. What they can do is if there's a new default, they can file a new foreclosure action. Okay? So now the other piece is sometimes you have options of a repayment plan. So when you're doing, let's go back to the loan modification. So you are negotiating with the lender to do a loan mod, which potentially they have different options and different lenders do different things. It is very helpful to know if it's a Fannie or Freddie or FHA, there's a lot more options available to the borrower and a lot more assistance available and a lot more likelihood of getting a loan mod, okay? If it's not one of those government-backed loans, then you have more difficulty in actually getting the loan modification. And so in this particular case, loan modification options, they take the entire balance, they put it on the back end, okay? And now the person continues to make payments. They take the entire balance and they spread it out over the next 12 months in order to keep making payments and add it to the mortgage payment. So it doesn't really make sense. Sometimes they'll waive and they'll reduce, they might do waive balances or waive payments or waive things and adjust. Or sometimes they'll extend the loan from 30 years to 40 years, adding 10 more years to the loan, which then reduces the principal. If you're familiar with mortgage finance and mortgage finance law, the amortization schedules, when you go out from 30 to 40 years, you're adding 10 more years, they're paying a lot more interest. That's 10 more years of interest. But then that principal gets spread out over a longer period of time, which then lowers the overall payments. In the old days, I call it the old days of 08, they used to do reduced interest rates where they drop the interest rate. So if they're at a 6 or a 7% or 8%, which was not uncommon then, they would drop that down to a 2% or 3% for a period of time to allow the borrower to get back on their feet. But now they're at 3 and 4%. And it's interesting, what we are seeing in some of the foreclosures we're seeing. We're seeing people filing and they have tremendous amounts of equity, but they're cash poor. So they lost a job, they lost their position, they were downsized, or they're not making as much as they used to, or maybe they were 2 household income and 1 member of the household lost their job. So we're seeing a lot of that where, or that they've had some sort of major difficulty taking place in their lives. And by difficulty, I don't mean like death, but that happens as well. But also, it's amazing how tight everybody's operating in terms of cash flow, right? People are usually working from paycheck to paycheck, or they're maybe 2 or 3 paychecks ahead. And in that particular figure that you're going to, if a person's transmission goes out, that's $2,000 to $3,000 to $4,000 to replace the transmission. If they get 2 flat tires, or if the water boiler goes out, these are common things examples that I'll give. But each of those are thousands of dollars of repairs that a person was not anticipating, right? And so then they're actually deciding, do I pay my mortgage, or do I fix my car to get to work? Or do I pay for the water heater or the HVAC unit so I can have heat in the house, or air conditioning? So these are things that people will face, which will then stumble them into a foreclosure. And the misnomer is that people who are in foreclosure, which I totally do not believe, and I'm totally against, is that these people who are in foreclosure are some deadbeats, or totally broke people, super poor, and they're totally broke, blah blah blah. And not at all. It's a significant number of middle class professionals who fall into this. I mean, I know attorneys who've gotten a foreclosure. I've been in foreclosure at least twice. And so things happen, life happens, right? And so it's, how do you manage that process? And it can happen to anybody. So I'm going to a little soapbox there, but so anyway, so the statute that governs in the list pendens that gets filed is under 2-1901. That's where they file the list pendens. That's the public notices we talked about. That alerts prospective buyers. So if the property is being sold, they're not buying it with a foreclosure pending, right? So they know that there's a foreclosure pending. They're aware of that ahead of time. So that way that can be cleared off title and handled before they actually take ownership. It also protects the lender's priority and their interest in the property. So service of the complaint, there's a couple ways of service. One of them is personal service, substitute service, and service by publication. So in a couple of reasons, a couple of things. One, personal service is when a person shows up, an independent third party, usually a process server, or the sheriff, the county sheriff, will show up with a thick stack of papers, and they'll hand them to the borrower personally and say, at their abode, right? Or if they find them anywhere else, they can serve the person anywhere. They cannot go to their jobs. It's important, right? But they can go, if they find them outside their job, they find them outside the house, wherever they find them, they can go, are you so-and-so? And they hand the papers, you've been served. So that is personal service, when it's personally handed to the defendant that they've been personally served. Substitute service, on the other hand, is where they're serving someone other than the person, right? And there are rules regarding that. I don't mean like they can randomly show up and say they can hand it to some random person and blah, 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 but they can serve someone who is over the age of 13 in the household that you're living in, right? And so this is important because a lot of times there's old information, right? People have moved out of the house and now they're renting it, or people have moved out of state or out of country and they're not there anymore. And so but they still have the house, they're still paying on it, right? So it's important this can be very gray in terms of the service, right? So they may serve, I've had people who they've served the cleaning lady, right? Or they've served the receptionist at the front desk, and you have a huge office and it's one of these Regis or these types of workspaces, right? Where there's like 30 companies and she's just a receptionist who's just there. That doesn't count, okay? They cannot serve the secretary. That doesn't count. It has to be someone like a manager or an officer of the corporation or the registered agent, right? So substitute service on an individual is anyone over the age of 13 who also lives in the house. So if they served someone and they'll in the service of affidavit, which the sheriff or the process server has to file, they'll indicate who they served. So they'll say it was personal, or they'll say it was substitute. And then they'll give an estimate as to what they think the person kind of looks like, right? So you'll get Hispanic or black male or black female or Asian, Middle Eastern, right? Mediterranean, white. So they'll have different designations as the type of nationality of the person, as well as their estimated age, hair color. Sometimes they'll get into the length of hair, size, build, right? Eye color if they can. Of course, for me, it'd just be bald, right? So it wouldn't be a hair color. So those are important things that'll be in the service affidavit. And this is important as we go further. We'll talk about that. So substitute service is somebody else who lives in the house over the age of 13. Service by publication, now that's a situation that happens, and that has to be required. And every foreclosure case typically will do publication on the service because it only makes sense. And they have to, essentially. Otherwise, a random bank can show up and say, oh, you never served me, you never named me, right? And so now I get you didn't foreclose on my interest. And the reason service by publication is critical for the lender is so that way it puts an announcement to the entire world in a newspaper, hey, we're going after this property. And so that is sufficient to let the world know that something's taking place. And if you have an interest in this house, you should show up and do something about it, right? So in addition to the lis pendens on the title, you're going to have the publication across the board. Publication does not replace personal service. I say that again. Publication does not replace personal service. Publication does not replace substitute service. Okay? And so the reason that's important is because now if they tried multiple times of finding the person, let's say the person died or moved out of the country, or could just plain simply be avoiding service, right? Every time they see the process server, they hide under the bed. That is then the movement then is to say they can do by posting, and really it's by publication, okay? But they have to show, the process server or the sheriff needs to show diligence that they tried going to the property multiple times at different times of the day on different days of the weeks. So if they go 3 times, they can't go Monday at 2 or Monday at 9 a.m., Monday at 1 p.m., and Monday at 11 p.m. or 8 p.m., whatever it is. And service has to be within certain timelines. It's very, let's say, between 8 and I think it's 8 and 8. There has to be multiple, it has to show diligence and multiple days, right? Now, multiple days is not specific in the statute, multiple days, but the reason I say that is from a practical standpoint. One of the defenses that I raise about service, if they try to say, oh, we tried to serve him, but we couldn't find him, is that, well, you could have found him because that's where he lives. And let me see what address you're going to. Oh, you're going to the wrong house. Or here's his driver's license or her driver's license, and this is where they live, right? So these are all things that would bring up. And if they only went to the house every Monday, and I'm like, well, the guy works every Monday, right? So that gives a justification that we're not doing actual diligence, that they can skip the first 2 options and go straight to publication, because they can do publication against that particular defendant. Okay. So one of the things that we do is when service is terrible, or when there's a question about service, did they actually get served, is a motion to quash. And the burden of the motion to quash is on the defendant. So we have to prove with third party, like him, like the defendant getting, writing an affidavit saying, oh, I didn't get served, totally insufficient. That's what we call a self-serving affidavit. Okay. Self-serving affidavits don't work. Now, a self-serving affidavit coupled with third-party evidence, such as work records, time cards, right, or sign-in sheets, or another one that I've used is tolls, right? So if they go through a toll booth in Batavia or something, right, and it says that they served him in the city of Chicago, well, there's no way you can go from Batavia to the city of Chicago in 5 minutes. It's impossible, right? Even the best of drivers. I don't care how fast you're going. It's just not going to happen, right? So that can explain, well, they were in the car, they were this at the time, blah, blah, blah. So there's no way they could have been there. Other types of appointments or third parties that might have been with them, or they could have been in school. right? So any third-party person, hospital records, let's say they were hospitalized. I have had that situation where I've had the hospital confirm that they weren't where they're located. Also, interesting enough, sometimes they get the service wrong, right? So they'll be serving a property thinking that it's the primary residence, when in fact it's no longer the primary residence and the person moved. So what does the driver's license say? If the driver's license is different than where they served, that's a basis for a motion to quash. Okay. So as detailed as you can in your motion to quash, you want to lay out the facts, you want to lay out the details. You need to have the service affidavits to show the attempts that were made, because that's what you're going to be challenging. And you don't want to come in and say, oh, because you don't know when they're claiming they served him if you don't have the service affidavit. The service affidavit will state, on this day, at this time, in this condition of weather, I served this particular person. And then that's what you have to refute. And the presumption is that they're correct because they're not self-serving, and the burden is now on the borrower to prove that they were not served. Okay? Now, there needs to be some sort of benefit for a motion to quash. One thing is it restarts the clock. So this is something, if you're really further down the line, or you're past judgment, or you're anything past judgment, and you have a possibility of filing a motion to quash, I would file that every day, right? And the reason I would say that is because you want to restart the clock to give you as much time as possible for the maximum number of options available, both for defenses, counterclaims, and for exit strategies for the borrower. Okay? So the other option is you don't want to waste a motion to quash if you don't need it. So if, let's say, you're early in the process, right? So the judgment has been entered, you stepped into the case, and they haven't been served. Yes, you can file a motion to quash at that point and restart the clock. And essentially, you're adding 3 to 6 more months, which is fine. I think the better move is to see if you have and find whether there is any counterclaims or other offensive actions you can take for consumer actions, consumer claims that you can take against the bank, which actually have more oomph. Now, sometimes you want to file those on a separate cause of action and not in the foreclosure. Sometimes you want to take those to federal court because some of them are federal statutes, right? As opposed to going under the state statutes. And other times you want to stay under the state statutes. So that's another presentation that we would do later. But I will say, though, that this is strategic. One has to look at the total number of available options available and what makes sense based on the venue, based on the forum, right? Those are two and the jurisdiction, right? Do you want to take this federal or keep it state? Okay. So now borrower defenses. We're going to talk about some of the borrower defenses. And we talked about there's standing, there's assignment, there's notice, there's loss mitigation, and there's service, right? Those are some basic ones. Other ones I would add is like civil litigation, right? Some civil claims. So there's requirements that they have to file certain notifications, certain documents, certain things. So going through the Illinois Mortgage Foreclosure Act, right? And using that as a basis, to make sure that they followed each of those steps, right? Those are what I call technical defenses. So they technically did not follow the rules and do what they're supposed to do. One of them would be like on a HUD claim, before a HUD loan can go to foreclosure, an FHA loan can go to foreclosure, there must be a HUD interview that takes place, right? Where they've actually spoken to the borrower to find possible options that are available to the borrower in order for them to actually, before they can move to foreclose. And that becomes what we call condition precedent. Before they can actually foreclose, they have to satisfy that condition to move forward, right? Maybe they got the dates wrong on the default. So those are some of the complaint itself, which is unlikely, but maybe there's mistakes in how they wrote up the complaint. Considering that a lot of the foreclosures are done by some of these foreclosure mills, we'll call, right? That are doing thousands and thousands of foreclosures a year and have been doing them for the last 20 or 30 years, but the same ones over and over again, you're unlikely to find those mistakes. But you will find them possibly with some of the smaller firms that maybe do this, maybe they do one-offs, or they do 10 a year or 15 a year. Those are the ones that can be assignment issues. Now, in the old days, and briefly we'll talk, and I'm not going to go too much into it. We're going to go talk about standing, right? So we talk about assignments, failure to proper notice, loss mitigation claims. We talk about service, right? And so on the standing argument, that is really my opinion, and you'd ask most judges, it was pretty much a dead argument. Even though I think it's valid, I will say this. The standing argument essentially is what has taken place, some history. When you take out your mortgage or note, you sign the mortgage, you buy the house, or you do a refinance. That the note and the mortgage are two separate documents. The note establishes how much is owed. I will pay this amount. I borrowed this amount of money at this interest rate. I'll pay it over this number of years. It'll mature over such and such time. I got to make my payment to this PO box or this location and drop it off, etc. So it lays out the terms for my repayment of the loan that I took. Okay. What it does not have is the enforcement provision that the bank is looking for in the event I fail to pay. Now, there's enforcement provisions in the note, but the one that doesn't attach to anything, it's just unsecured debt, like a credit card debt. However, what actually creates it a mortgage is in the actual mortgage document that is recorded and signed by the borrower. And if there's a spouse, there's a waiver of homestead, right? And now the homestead laws have changed as of January of 2026, which is beautiful, right? It doesn't apply to mortgages, but does apply to judgment creditors. So that's a whole other procedure we'll talk about. It's another session, but here particularly, the moving from the so what they've taken is they take that note, and the banks take that note and they resell it, and they moved it from place to place. And by moving it from place to place, what they've essentially done is they've sold it from party to party to party. Then you've got servicer to servicer to servicer. So they don't have the note anymore, because the note, in order for it to be bare paper, has to be the original note. And so they lost the note. They don't know where they put the note. It disappeared. And the person who has the note claiming to foreclose doesn't have the note in order for them to actually say that they can move forward on the foreclosure. And there's also securitization issues, which is no, but the point is, this standing argument has, even though some people raise it, the judges have said no, they've knocked it out. There's a case that's a very famous case called the Bassman case, Bank of New York v. Bassman. And it was, no, Bank of America, I'm sorry, Bank of America v. Bassman. And so what they've done is that essentially eliminated the whole argument of standing, and for people to argue that. And so judges really have kind of pushed that aside, which has moved us into counterclaims, right? So notice requirements, really quick. You got to have a notice of default, right? There needs to be a default notice saying you have defaulted. There needs to be a cure amount that has to be clear, right? How much do I need to cure my default and bring me back into good standing, right? The cure default must have at least 30 days to give for me to actually cure before that notice of acceleration is issued. Okay. So these are things, if they haven't done these notices properly, then these become claims that can be brought. And this has to be taken place before any judicial action can commence. Pursuant to paragraph 22 of the standard mortgage form, this is the most common litigated provision, is the notice provision, right? So did they provide proper notice? And you argue that they haven't, and so now they have to prove that they have. Okay. Now from judgment to sale, let us presume that, so I want to, before I get to judgment to sale, I'm going to throw in some little extra notes here, right? So I'm going to throw in some extra stuff. Let's see, we still have no questions. So feel free to ask any questions. We're free to hear questions. Anybody who's want to ask questions, I love questions, just throw them at me. So one of the things that I want to talk about in terms of different types of counterclaims to bring in a foreclosure action, you have violations of the FDCPA. FDCP is the Fair Debt Collection Practices Act. Okay, that can be brought in any one of the claims. So you have an option there. The next one is violations of RESPA. RESPA stands for the Real Estate Settlement Procedures Act, which is what is used to actually, when you bought the property, there was a settlement statement which had all the numbers of what you owed and everything else. Well, the RESPA includes everything that was signed at closing and how to do things. So notice of errors. If you have a notice of error letter, you can send those out. And so what we do is we'll send out these letters to trigger to see if they're going to actually comply. And we'll find an error and ask them to respond to it, and a request for information. Give me information about my loan. Give me escrow issues. And if they respond, fantastic. If they don't, that becomes a violation, right? Failure to properly respond to loss mitigation applications. If you've done a bunch of loan mods and you send the loan mod, it takes them forever to respond. They never do respond. And then like, oh, we lost the package. So you'll find that the banks do this. Some people say it's nefarious. Some say it's intentional. Some say it's just total negligence, right? So what they'll do is we call that dual tracking. You're negotiating for the loan mod and they're pushing forward on the foreclosure. So that in itself is a potential violation, right? And so you bring that as a claim. Mishandling of escrow accounts. TILA is another one, Truth in Lending Act. Providing inaccurate amount on their loan statements. So let's say the loan statement is incorrect. They've got the wrong interest rate. They've got the wrong payment amount. They added too much in escrow, or so they made any mistake. Those types of things can fall into Truth in Lending Act violations, which have statutory fines as well as attorney's fees. And the purpose of bringing these consumer statutes is to shift the attorney's fees. So in a foreclosure action, the loan documents clearly state that when prosecuting and enforcing those documents, they get to collect attorney's fees. However, if you bring a counterclaim and they're defending the counterclaim, those defending the counterclaim, their defense of that, the bank's defense of that, they can't charge you attorney's fees for that, right? They'll try, but they can't. And so and it's hard to distinguish between what was for this defense or that defense because they're showing up to court for both issues, right? Because it's happening in the same courtroom. But they can't come back and get attorney's fees for defending your counterclaim. And if you bring a counterclaim and you prevail, it shifts the attorney's fees from you to them. So now the bank has to pay your lawyer fees, right? And so we've had many successes where the banks will pay out settlements to our clients, anywhere between 10 to 100,000 or more, to our clients as settlement for the violations they had in these various statutes, right? Plus our attorney's fees. The other thing is the Fair Credit Reporting Act. So maybe they made a mistake on reporting your debt or your missed payment. Maybe you missed 2 payments and they said you missed 3 or 4. Those are violations, right? Breach of contract. So anything they've done that is a violation, for example, violation of paragraph 22, which we talked about in terms of notices that are required. That is a breach of contract. Consumer fraud violations, common law fraud, right? So we've had situations where we might have a construction loan and they're claiming they issued the money and they didn't, they gave it to the wrong person. Or the bank, I mean, I've seen so many crazy things in things where like the banker's involved, right? Or the banker takes out a loan with some other, it's just crazy stuff that we've seen, right? So I just want to give that, just to give you an idea. So want to move quickly so we don't lose anything. We got for judgment to sale. So the judgment foreclosure, the judgment essentially is saying how much is totally owed. And so the total amount that's owed is the principal, accrued interest, fees, costs, right? So that fixes everything into the judgment. And so here's the downside. If the interest rate was 4% and they foreclosed and they get a judgment, your judgment goes to the judgment interest rate, which is at 9%, right? So that the annual interest rate on a judgment is 9%. So these are things to be aware of, that when your client's like, oh, well, just let it go and let the bank take it back. Here's the problem. Judgment gets entered. Now they have a dollar amount they're owed. And if that dollar amount exceeds the value of the property, right? And it doesn't have to be the market value, because what happens is the bank will then take the property to a sheriff's sale and it's whatever it's sold at the sheriff's sale. And here's the really, really terrible part, right? The bank can buy the property back at any price they want if nobody else bids. So if the property is worth $500,000 and no one shows up to bid, and the bank is owed 300 or 400 or 500,000, right? The bank can bid 300 and force deficiency because they bid against themselves and say, oh, nobody else bid, so they'll low bid it. And so now there's a deficiency when there shouldn't be one because the property is worth more than the loan. But the bank was able to short that in the sheriff's sale in order to get a double dip of a deficiency judgment. So I want to be very careful. The deficiency judgment is dangerous. And if you don't know, you don't litigate. Deficiency judgments are good for how many years? You don't know? 7 years. But here's the crazy part. It's up to 21. So they can come in, the law has passed, there's a law, that the judgment expires after 7 years. However, at any point in time within the next 20 years, a person can come in and renew that judgment at any point in time between 7 and 20. It doesn't die at 7, right? They have to renew it. And that's merely filing a motion with the court and saying, I want to renew the judgment. And the judgment renews. And for they can't take them longer. I mean, there are some plaintiffs that have played the games and the timing where they can actually take it to 27 years or 24 or 25 years, but it's 20 years on a judgment. And at 20 years, that's when it ends. So if a person gets a deficiency judgment from a sheriff sale that took place that shorted them, that's chasing them for 20 years. That's 20 years going after their wages, 20 years hitting any other properties they go into, 20 years attaching to their cars, 20 years attaching to their bank accounts and bank statements. And like typical, IRAs and those types of investments aren't touchable. Social Security is not touchable. However, if my father, for example, places a Social Security in an account and I put money in that account, any money different, separate from Social Security can be garnished, even if it's not his. Right? So this is very important. You do not want a deficiency. So anything that can be done to avoid a deficiency is the best move for your client. Okay? Now, obviously, if they get a deficiency, there are bankruptcy options available, but some people may not be able to file bankruptcy because they have a second home or they have another property or they have other assets. So something to be considering is look at the totality of the situation for your client. Redemption periods. Now, the redemption is from the time the judgment is entered, right? It gives the opportunity, the borrower, time to redeem the property. And by that means, tell me how much is owed and I'll pay you off in full, right? So that redemption is a period that takes place after the judgment, and it's a statutory window to do that. And here's the redemption period. It's 7 months after service or 3 months after judgment. And why is that different? Because the case, they may have served the defendant in January, and the case just dragged for 2 years, and then they get a judgment. And the judgment that takes place 2 years later gives the borrower now 3 months from that judgment date to redeem the property. And that's coming up with the entire amount that is owed, paying off the lender in full as redemption. Okay? Judicial sale. So the sale takes place as you have a third party that is selling the property. The bank can't sell it themselves. They have to hire a third party. So you have these auction houses. Judicial Sales Corp is one of them. Intercounty judicial sales is another one. The sheriff's office also does their own sales, right? So you can hire the sheriff's office to sell the property. The bank will do that. And so at the sheriff's sale, it is a controlled sale, which means the lender comes out there and says, here's the minimum bid, and they decide what they're going to accept or not. So that bidding can keep going and going and going and the bank can bid all the way up until the amount that they're owed. So if they're owed more than the property's value, they'll just take the property back, most likely. And they'll figure out some way and they'll sell it on the secondary market. They'll sell it as an REO later and hoping to get more money that way. All right? Because they figure they can market it for a longer period of time and not for just a few weeks. That's the lender's credit bid. Now, the sales conducted, you have third-party bidders. Now, this is where it becomes a little more dangerous, right, for the borrower. A third-party bidder, what they'll do is it's a third party unrelated to anybody will come in and bid at the auction to acquire the property. Usually, typical, these are investors who've come in and said they want to buy the property and think they can get it, hoping to get a good deal below market before it gets onto the open market. Okay? And when there's a third-party bidder, if there's surplus proceeds, there's options for recovery of the surplus proceeds, which is money that was in excess of the amount that was owed by the lender or owed to the lender. Here's the downside. There's no requirement for that. So I can almost guarantee you that there might be if there was a surplus, they still didn't get the full amount of the value. Because on an open market, listing the property, using a real estate broker, right? A licensed real estate broker, that gives the opportunity to actually go ahead and list and sell the property. You can get the highest and best and maybe create a bidding war and create people to come and acquire the property. So If there was a surplus, that was a lost opportunity for your client to actually collect all the money that they were owed, or they could have collected it and they built equity in that property. Another eradication of generational wealth. But third-party bidders can actually create, that affects the redemption ability. Confirmation of sale. So essentially what this is, the confirmation of sale shows is when the sale's taken place, the court must affirm the sale. They must state that the sale was conducted properly, notice was proper, everybody was served, the defendants did what they're supposed to do. We have a default judgment or summary judgment if there's an answer that was filed. We didn't get into that, but the confirmation of sale confirms everything. This is it. Nail in the coffin, dead. If the sale has been confirmed, there's almost nothing that can be done except for service. So long as the borrower never showed up to court, service can quash this and start the entire case all over again. Okay? Also, as you get past judgment and closer to sale, the loss mitigation options become fewer and fewer and least likely. So, and once the sale takes place, loan modification out. Once the sale takes place, no short sale, out. So a lot of times, and one of the things that we've done is we'll step in to stay the sale in order for a pending short sale for approval or submission or a loan mod to be considered. Okay? So resolution pathways, we got a few more minutes here. So we talked about loan modifications. We talked about repayment plans, right? Catching up on arrears. We talked about reinstatement, reinstating the full amount, the back amount that's owed, right? We talked about short sales. A deed in lieu, so, we'll talk about that as well, right? So on the loan modification, essentially they're doing either interest rate reductions, extending the loan terms, principal capitalization, so they're taking the unpaid amount and recapitalizing it back into the loan, right? So now your total loan is higher, right? So that might end up with a balloon payment at the end, or that might end up with an extended loan term, okay? Or adjusting the payments to account for those payments, right? So there's multiple options that are available, and there's federal servicing guidelines that requires the options that they make available. So we can't go into those now because those are very detailed, but there are federal servicing guidelines that tells them for Fannie, Freddie, HUD, FHA, VA, and farm loans, et cetera, as to what their options and how they have to handle the loss mitigation. And if they violate those, that becomes another claim that can be raised as a counterclaim against the bank. Okay. So now short sales, we talked about so the short sale is interesting. When you're buying a house, they're underwriting you that you qualify to pay the mortgage when you're buying a house or doing a refinance, right? You make enough income, you're sufficient income, you have sufficient down payment, sufficient equity, you got enough skin in the game, you got good credit. All these things are set up to help you buy the property. On a short sale, it's the total opposite. They're underwriting you to show that you are incapable of continuing with this loan, right? So a client that has large bank statements or bank accounts with huge statements, those don't need, they're asking for bank statements. I would say you be choice as to what you're providing, right? So you provide a bank statement, you provide the bank statements that they're using, right? If they have huge 401ks, those are not necessary, right? If they ask for those are non-recoverable, right? Or usually they don't ask for that. They'll ask for your financial statement as to what your situation is related to the property. And each lender has their own circumstances. Some ask the questions, some don't. So you want to be able to understand what are the specific lender requirements. When you're calling for a loan mod, you ask them to send you that loan mod application. You can fill it out. Short sale requires a lender's approval. So they're going to look at your financial hardship. Very simply, I can't afford to make my payments. You're creating the default. Your lender is reviewing that. They're going to do an approval, and they're going to say you're laying out. And the short sale is a whole process, but essentially you're telling them, I have a contract. Here's the buyer. Here's the seller. Here's the contract. Here's what you're going to pay out. Here's what's available. And after all the expenses are paid out, this is what's netting to the bank. And the bank will say yes, no, or counter. Okay. And when they counter, it's not a final. Or when they say no, it's not a final. Sometimes you have to modify the numbers, adjust some things here and there, find out what their appraisal was, right, to see it as it is. And the purpose of doing a short sale is to eliminate any risk of a deficiency. A improved short sale wipes out the deficiency because they're accepting taking less in exchange of actually foreclosing on the property. It also has a huge benefit to the borrower because a short sale has less damage than a final foreclosure action. All right. So here's some of the documents briefly: hardship letters, financial statements, listing agreement, purchase contract, estimated closing statement, right? And all the contacts are done with the loss mitigation department. Deed in lieu of foreclosure. Yes, it can happen faster, but they will not accept the deed in lieu if there's a homeowners association or unpaid HOAs. They will not accept if there's a special assessment, and they will not accept it if there's any other debts or liens or interest on the property. So that's not going to work, right? Also, the deed in lieu, sometimes with a short sale, you can get cash for keys, where they'll give moving expenses of $3,000 to $5,000 to the borrower. I've gotten as much as $10,000 to $20,000 for my clients when they're leaving the property to help them move out. Okay. Practical litigation intake tools: motions to dismiss, motions to strike or quash, motions to stay sale, right? Those are some clear things that you can use, right? Motion to stay foreclosure sale. You want to make sure that you've got a pending short sale that you're moving forward on. You've got it, that you've tried the loan modifications, that you've gone through settlement negotiations. The more documentation you have, the better, right? So you're essentially telling the judge this is likely to happen. And I've had them continue 2 or 3 times, right, trying to get it approved. And the way to get it more approved is by showing that the bank has been acting in bad faith, where they haven't considered, they haven't reviewed, or they've rejected, or they asked for things that they've already asked for, or they have in their systems. Is a good way of actually helping out. Now, the borrower who waited too long, oh my God, these are terrible, right? Like, I just want to shake them and be like, what were you thinking? Like, I've got borrowers who showed up the other day and said, oh, we got a confirmation of sale, we got a huge deficiency. I'm like, where were you? Like, you had a whole year of dealing with this. Where were you? And I can't fault them too much because the emotional toll is huge. But the rights they lose is the ability to contest the lender's standing. Do they have a right to actually foreclose? To raise affirmative defenses and counterclaims, procedural protections that they lose service of process. Now, there's still options post-judgment where you can vacate the default at any point in time beyond the 30 days, as long as you show some diligence. Direct negotiations with the lender, loss mitigation. So the key takeaway is the sooner you jump in, or the sooner you get your client to actually take action and step in with you, the better, the more options that are available, right? So kind of roll through these pretty quickly. Borrower waited too long, poll question, motion to dismiss, right? Case intake checklist. You want to make sure you get the mortgage and note. Good to know the payment history, get a copy of the foreclosure complaint, and the financial documentation and hardship explanation. And it's really important you want to do this. You want to coordinate with real estate professionals. I know we're running a little bit over time, but you want to coordinate with real estate professionals. There's such a great resource to get your client across the finish line, right? And a win, in my mind, and I've taught my clients and worked with for many, many, many years that we've been doing this, we've redefined win. A win is not like, oh, I got my house for free. The win can simply be that they stayed in the house for 2, 3, 4, 5, 6, 7, 8, 9 years, right? In the house while they're getting their lives together, or the kids get through high school or get through college or whatever the case they're trying to do, or grade school, right? And then they sold the property. So working with real estate brokers to get actual valuations, or to list the property for sale, or to help you find short sale buyers who are coming in. Title companies to help you clear title and work with them. Companies are worth so much, right? And you're dealing with the lenders and the servicers. So some ethical considerations. Last and final note: never promise anything. You can't promise anything. No promises, right? You can promise you're going to be diligent. You can promise that you're going to follow up. You can promise you're going to be involved in the case. You can promise you're going to take actions, but you cannot promise outcomes. That's almost anything. Baseline and legal process. Attorneys don't promise, right? Do not misrepresent their eligibility. We can say that you might qualify for a loan mod based on the preliminaries, but it depends on the lender. So we don't know if you could qualify, but it looks okay, or it looks within reason, or falls within certain parameters. It makes sense. You have income. We're going to try, right? And never exceed the scope of your representation. Be careful of that, right? Because that can create some issues. So all in all, I want to thank you all very much for paying attention and staying on board and listening. My name is Mahmoud Faisal Elkhatib, Mahmoud Faisal Elkhatib with EV Haas Attorneys at Law. I am the Bowtie Attorney. You can Google me, you can find me. It has been a pleasure. Thank you so much. And if you want to get a hold of us, you can reach us. You can find us at www.foreclosuredefenselawoffice.com or evlawgroup.com or the Bowtie Attorney. And all those places you'll find us. We're on social media. And if you want to call my office, you can call it at 312-775-0980. We'd love to hear your comments as to what you thought of this stream or whatever. We'd love your comments and your questions. Hit us up. Thank you so much.